Again, we're going to have to start in a couple of minutes here now. You can charge your computer or whatever you brought with you. There's some electronics underneath the table in case that might be of help. I notice I keep thinking the line's going to go down outside, and that we'll get started in a couple of minutes. But maybe we should get started now. We don't want to run too late in our program. So let me say, first of all, again, good morning. And welcome. We're delighted to have you here. It's really a real pleasure to have you attend our 2025 governmental and nonprofit accounting updates. So this seminar, of course, is for you, our clients, and our friends. We picked a different venue this year. We thought that we knew we were going to have more people. We also want to make it a little bit nicer, and hopefully it was a little more, a little easier to get to. We're pleased to, a little plug for our firm, we're pleased to inform everybody that Accounting Today, which is one of the accounting journals that us accountants read and is highly respected, takes a poll and a survey. And the last 2 years, including this year, we are now among the top 40 largest firms based on the West Coast. So we're proud of that. Thank you. And it's really thanks to you, our clients and our friends. We could not have attained this recognition if it wasn't for you. So we're very proud of that, but very proud to be able to serve you as well. In today's economic climate, there's a lot of uncertainties. Business is always tough. You know, business is not easy. If it was easy, I guess we'd all be in business and we all make a lot of money. But every day you got to struggle. Every day you got to think. Every day the landscape changes. And so today we're delighted to have an outstanding group of speakers to educate you on the relevant topics affecting your business. It's my pleasure now to introduce one of our partners. We have many partners that will be presenting today. He has been with our firm, he's been our partner, that's more important, more than 12 years. We hijacked him from KPMG. We have many partners from KPMG, by the way. He was in charge. He was not in charge, but he was one of the audit partners for their governmental sector. We're delighted that he is our partner and he leads our audit practice. And he in turn is, going to be the host for our general session and executive orders and their impact on grant reporting and compliance. And with that, it's my pleasure to introduce to you our audit practice leader, Roger Martinez. Roger?
Thank you, Gail. Hopefully you can hear me. I actually have the easiest job because all I have to do is ask questions of two wonderful individuals. So in this room, as the name says, we have a lot of not-for-profits and government agencies in all different sectors: transportation, utilities, social services, healthcare. Different models. But the one thing that you all have in common is your federal funding, which is obviously creating a lot of issues for many of you and actually just the whole industry as a whole. We as accountants are getting a lot of guidance because there are a lot of things we need to test. The federal government is telling us that we need to test certain things, which is why it's very important that during today's meetings, you take a look as to what we're looking for in terms of compliance. The best way that we can help you stay in compliance, stay out of trouble, is by showing you what you need to do. Having said that, we are delighted that Deborah and Tom are here with us today. I just want to give you a brief introduction on Deborah Rothenberg. Deborah is a partner with Murphy Austin Adams. She has over 18 years of experience in Medicaid, Medicare, and other issues impacting healthcare organizations. One of the areas being impacted significantly because of the executive orders. Deborah often serves as an outside in-house counsel and advises healthcare providers, DME providers, and clinical laboratories on a wide array of day-to-day regulatory compliance and reimbursement matters. Deborah is regularly asked to provide legal opinions and strategic guidance on a number of matters, including audits and investigations, in case all of you get impacted by that, public program participation standards, and clinical operations. Deborah advises both private organizations and public policy makers on legislative and administrative proposals related to healthcare. She has a particular expertise in legal matters pertaining to reproductive health care, including those relating to abortion care and comprehensive family planning services. Deborah received her bachelor's from UC Davis and earned her law degree from the University of California, Hastings College, now known as UC Law in San Francisco. Deborah, if you could please join us. Can take. Thank you. We're also delighted to have here Tom Saenz. Tom is a prominent civil rights attorney. He returned to the Mexican American Legal Defense and Educational Fund, MALDEF, in 2009 as president and general counsel, leading national efforts to advance Latino civil rights. Prior to this, he served as counsel to Los Angeles Mayor Antonio Villaraigosa, contributing to major policy reforms, including the governance of LAUSD and civil labor negotiations. Earlier in his career, Tom spent 12 years litigating civil rights cases at MALDEF, where he played a critical role in challenging California Proposition 187 and Proposition 227, and secured major legal victories in areas such as immigrant rights, education, and employment. Beyond litigation, Tom has made extensive contributions to public service and advocacy. He has served on numerous boards and commissions, including Los Angeles County Board of Education and the Leadership Conference for Civil and Human Rights. I believe you're also the chairman of CCF, the California Community Foundation. Tom also has taught civil rights litigation at USC Law School and published widely on legal and civil rights issues. His efforts have earned him significant recognition, including being named one of Hispanic Business Magazine's 100 Most Influential Hispanics and received the ABA Spirit of Excellence Award. Tom is native to Southern California, and he holds both undergraduate and law degrees from Yale University, and began his legal career clerking for federal judges before joining MALDEF. And I believe something that I forgot is, I believe that, Tom, you have even gone all the way to the Supreme Court to fight for your constituents. Tom, thank you for being here. You can take a seat. So, you know, we really want to hear your thoughts. Once again, civil rights, healthcare are significant issues, and that are going to impact everyone here. Give us a brief update on your understanding of what impact the executive orders had on your fellow not-for-profits, on clients, or the communities you serve. Deborah, you want to get started?
Absolutely. So the majority of my clients are nonprofit corporations that operate healthcare facilities. They're known as community clinics, FQHCs, non-FQHCs. They receive a great deal of federal funding and rely heavily on the Medicaid program for their reimbursement. So another thing about FQHCs and most primary care clinics is they see patients regardless of their ability to pay and regardless of immigration status. You walk in the door, the community clinic is expected, and they do, treat you. They also actively reach out populations that have historically been underserved in healthcare to try to equalize these disparities. So they have, integral to their mission, DEI initiatives. That's the whole point. They're trying to reach specific populations that have had a hard time accessing healthcare in the past. So you can imagine the executive orders governing immigration status, DEI initiatives, have had a direct impact on the majority of my clients. In addition, as someone who specializes in healthcare related to reproductive healthcare and gender-affirming care, the recent executive orders governing those topics, well, gender-affirming care in particular, have sent my clients spinning. This is on top of the proposed Medicaid cuts, which is top of mind for everybody, and the economic uncertainty that we're facing in light of tariffs and other executive orders. So the short answer is, it's been rough. It's been rough. Most of the executive orders that have impacted healthcare have been challenged. The legal basis is that the president exceeded his authority in issuing these executive orders. And while those legal cases are pending, the executive orders have been enjoined or stayed. So the direct impact on my clients, at least, has for the most part been not yet felt, but it has caused anxiety about what is to come. That being said, we are hearing that in some cases, certain federal grants are including language in the notice of award implementing certain executive orders that have been enjoined. This is probably not entirely proper, but it is happening. So it's not, my clients are mostly okay, anxious, but not directly impacted. But we are hearing that there is some implementation despite the injunctions, which is causing even more concern.
Okay. Tom? So MALDEF has a mission to promote the civil rights of all Latinos living in the United States. We work with a whole network of civil rights organizations serving other communities, focusing on specific issues. So from the perspective of both the Latino clients that we serve and the nonprofit partners we work with, the effect of the executive orders has been increased fear and anxiety, the same as others are feeling throughout the country, pretty much regardless of what business they're engaged in. And it's important to note that that fear and anxiety is by design. The executive orders are designed to trigger fear and anxiety in the hopes of changing people's behavior in ways that would please the current administration. Now, first, we should pause and consider, what does it mean to have an elected leadership that has taken its main tactic to be inspiring fear and anxiety in its own constituents? Arguably, that is not consistent with a democratic approach to anything. It is an autocratic approach designed to change behavior through inducing, improperly, fear and anxiety. Second, I want to focus on that improperly. As Deborah indicated, many of the executive orders have been challenged. Others have not been challenged because they're actually not announcing anything that is implementable. They're simply stating the president's beliefs, articulating his threats, but without anything legal behind them to actually be enforced. So he's issued a lot of executive orders. Many of them are not orders. They are simply executive pronouncements, executive aspirations, if you will. They are not designed to have any effect other than to scare people into doing something different than what they're currently doing. And that is why it's so critically important, as I know we'll discuss further, for everyone to be as informed as possible, not just about the details of the executive orders, but determining whether they actually have any legal effect or any intended legal effect, then understanding what is vulnerable to challenge and may already have been challenged. The number of lawsuits challenging this administration is at a record-breaking pace. And sometimes there are so many that it's not readily accessible what's going on. And finally, being informed about where the law currently is and how the aspiration or order seeks to change that. But the bottom line with respect to that is the law has not changed. Neither constitutional law nor federal statutory law, with limited exceptions, has not changed since January 20th. So most of what you see, whether from the president in the form of executive order or from cabinet secretaries in the form of dear colleague letters, the most infamous to education institutions, these are largely statements of what the administration would like the law to be, not where it is today, and frankly, in most cases, not where it's likely to go anytime soon. So this is a time when avoiding fear and anxiety involves informing yourself as much as possible. It's why you all are here, and I congratulate you for that. But it's an ongoing effort to make sure you know what's in the orders, what's in the directives, whether it actually has an effect to be enforced, whether it is being challenged, whether it is a departure, as it is in most cases, from the established law that we are working under today.
So on that note, a lot of litigation back and forth. What have we learned from all of the litigation that is taking place? It's kind of hard to keep track. It seems like every day it changes. But what have we learned from?
Do you want to take that one first?
Well, I think we've learned that the courts are still a critically important part of our government. They have a critical role to play in limiting the excesses of the executive branch. But I think we've also learned, perhaps more than anyone ever wanted to, about how slow our court processes are. And in particular, when you get a preliminary injunction, that is not the final word. And sometimes higher courts will lift a preliminary injunction even if they believe that ultimately what's being challenged will in the end be determined unlawful and permanently enjoined. But they will lift a preliminary injunction just because that's supposed to be extraordinary relief, not the ordinary course of things. Now, some of us might believe it should be the ordinary course of things when something is clearly unconstitutional to stop it in its tracks. Another aspect of this, just to mention it, is the Supreme Court is currently considering, as you may know, whether nationwide injunctions should be allowed and when they should be allowed. Because in most cases, certain justices have indicated they think injunctions, preliminary injunctions, should be confined only to the state where the case was brought or to those who have brought the case itself. So I think we've learned both the importance, we have had reiterated the importance of the courts and how slow they are and how that deliberate pace sometimes means that laws and orders that are pretty clearly unconstitutional will be in effect despite that clear unconstitutionality.
I asked Tom to answer that first because he actually litigates, and I generally don't. I'm on the compliance side. I try to avoid litigation as much as possible. But what I would add to what Tom mentioned was I think one thing to consider if litigation is unavoidable, if you think you have no other recourse and you have to file a lawsuit because you are being adversely impacted by an executive order or the way that an agency is administering some sort of policy directive, make sure you understand thoroughly what that process entails. It is a lot longer and a lot more expensive than you think it is. And it is definitely not for everybody. It is worth it, in my opinion, and I'm not plugging myself just because I'm a compliance attorney here, but it is far better, I think, to explore ways where you can achieve your objectives, your mission, without litigation, remaining compliant with an executive order, but just doing things a little bit differently. With DEI, for example, and to Tom's point about some of these executive orders really just being like emotional proclamations more than anything else, if you read these executive orders, many of them aren't saying anything that you disagree with. The DEI orders, for example, largely say don't discriminate based on race and ethnicity. Okay. I mean, that's what these DEI initiatives were intended to do, was equalize the playing field. And that's essentially what the order tries to say it's doing by forcing the removal of DEI initiatives, is equalizing the playing field. So one idea is to just say, as you are an equal opportunity provider, you are an equal opportunity agency. You do not consider race and ethnicity. Now, that's not going as far as you'd like to in most cases because there are inequities, and many of you are intent on curing those inequities, which is a great thing. So it's not a perfect solution, but it is a far better solution oftentimes than litigation because litigation is so expensive and so long. So my thought would be litigation is a great last resort, but there's things to be explored before you do that, and you should explore those things.
And while I don't disagree with that, I do have to give a plug for litigation. Litigation is an important tool for preserving options and creating change. But I do agree it is expensive, and you do have to explore options to ally with others, to perhaps find a partner that is able to provide pro bono assistance depending on the specific policy issue that you may be seeking to litigate. So I agree that maybe not the last resort, one of the last resorts that you should consider, but it's a necessary resort in a number of cases. And we really do have to push back, or those pronouncements will continue and get worse and continue to undermine the law. So I just want to pause, if I could, just to talk about one aspect of the DEI, which is disparate impact. You may have heard this term because this administration is seeking to eliminate it, just like DEI, from our vocabularies. But disparate impact is still the law in a number of areas, including, most prominently, employment. So while it is important to indicate and follow equal employment opportunity policies, disparate impact also says you have to evaluate whether you're using criteria for selection that have a significant discriminatory effect on particular racial minority groups. And if you are using a criterion or two that have that significant discriminatory effect, then under the law, you are obligated to remedy that, unless you can demonstrate that the criterion or criteria that have that significant discriminatory effect are necessary. They are required to get qualified people on the job. Job necessity, it's sometimes called. Unless you have that, then you have to choose criteria that don't have significant discriminatory effects. Now, most people, when that's explained to them, don't have any problem with that idea. It basically says you can't adopt a test, for example, that shows that Black and Latino test takers score significantly lower despite having the same education, for example, than white test takers. That may be a problem under this theory. Most folks won't have a problem with that. This administration does. Because this administration's real goal, despite what the language says, it does talk about discrimination, absolutely true, its real goal is to reimpose white supremacy in the workplace and in all kinds of other areas of life. And the last thing I want to say is a little plug. So we call it DEI. Trump administration doesn't like it. But my view has always been that we should lead with equity. The only reason we lead with diversity, in case you didn't know why, is because a very conservative Supreme Court justice way back in 1978 said diversity was the only justification for considering race in a limited way in university admissions. He specifically rejected combating discrimination. He said diversity is the only reason. So we all adopted diversity first, diversity, equity, and inclusion. Well, diversity is important, but to me the most important is equity, because it embodies so many of the constitutional principles that every American believes in. So I'm urging folks these days, every chance I get, to call it equity, inclusion, and diversity, EID. And the virtue of EID also is it's also an acronym for Ending Irrational Discrimination, which is what DEI, as Deborah said, is about. It's about ending irrational discrimination, equity, inclusion, and diversity.
So it's great that we're getting both perspectives, compliance, litigation. In the meantime, many of our clients are being negatively impacted, whether if it is grants that are being put on pause. We started the year with a lot of our clients getting notices in that their funding was being stopped. We talked to some other clients where grants, millions of dollars being canceled, and money's being asked to be returned immediately to the federal government. What options do entities have? Not everybody has huge budgets that they can afford litigation. So what can they do in the meantime?
So I will foreshadow my answer by telling you that this will ultimately be a plug for MALDEF and other legal defense funds. But before I get to that, what we saw at the beginning of the year, at least in the healthcare space, was, as you mentioned, Roger, lots of notices coming out saying, we're freezing funding, we are stopping funding. And then there were lawsuits, and the orders that prompted those notices were enjoined, and much of the funding was released, and we're seeing less of that now. If down the line we start seeing real funding freezes, rescission of incoming grants, or just canceling entirely, your options are no one likes to hear when a lawyer says it depends, but truly it depends. It very much depends on what prompted the change. Was it the executive order, or did Congress change the underlying statutory authority that appropriated the money to begin with? These are very, very different worlds, so the remedy available to you will be different depending on how the change came into play. Usually for grants, that federal money is considered obligated, and it's very difficult for Congress or the president to touch it. It's not impossible, but it makes it more difficult if it's obligated federal funds. So assuming that let's assume that that's not the case. Let's assume instead that it is a policy change. You were given money to effectuate a certain policy at a time where it was a different administration, the Biden administration, and your activities were perfectly compliant and consistent with policies in effect at that time. Fast forward to today, policies have changed. You get a note saying we are canceling the grant for the reason that it is now inconsistent with federal policy. How to determine if that action is permissible or not, the first thing to do is read your award. Your award is essentially a contract. It contains terms. So is it in the contract? Is it in your award? Oftentimes, at least in the healthcare space, it is. Now it can't be abused. There has to be a rational basis for making that determination that the policy has changed and now the use of the money previously awarded is inconsistent with current policy. So it's not that it's not reviewable, but step two then would be how do you have this reviewed? Usually you have to exhaust all of your administrative remedies before you can take it to a Article III court. Not always, but usually you need to have the administrative agency review their decision internally. This sounds like it's going to be gamed against you. Most likely it is, to be honest. But they will review their decision, and this all takes time, and you probably will hire legal counsel to help you through this process. So the clock has started ticking, and the money now you're spending money. And this is going to take a very long time. The administrative agency does have timelines that they are required to work within to re-review their decision, and who knows how many levels of appeal within the administrative agency might be available to you. If there are multiple levels, you have to use them all before you can appeal to a district court, usually. So that's more time, more money. If you exhaust all of your administrative options, you can then appeal it probably to a federal district court, an Article III judge, who can review the decision and make a determination themselves. Historically, that has not worked out well. For a ton of discretion was given to administrative agencies. It's a new landscape in that regard. I don't know that it's necessarily going to be better, but the discretion normally afforded to administrative agencies is no longer presumed in Article III courts, so potentially it's a better shot. But by this time, it's a good chance that it's been 3 to 5 years since you initiated this process, and that is a lot of money. So what I would recommend is you would contact a legal defense fund that has a great deal of experience litigating these matters, fighting these matters, and can advise you on whether or not this is a case that is within their mission, if this is something that they can do, because for a single grant, even if it is the backbone of your organization, this is going to take a lot of money to appeal, and it's an uncertain outcome.
So I just want to emphasize a couple of things in Deborah's terrific answer. First, it does matter if Congress acquiesces in what the president and his administration are doing. And that is an ongoing process. Right now, of course, the budget is before the Senate, and a lot of these issues could end up being embodied in that legislation. So first and foremost, you need to weigh in with your Congress members about what you expect to see with respect to these matters in the budget and in future legislation. Because it is critically important whether the administration is acting on its own, implementing its own policy, or following congressional policy. So please make sure that you are paying attention to what's going on in Congress and how it might affect your contracts, and make sure that you are weighing in and asking others to weigh in with your Congress members and senators about what is important to you. Second, background for what Deborah has said, and I want to say this so everybody knows it, because there's lots of misunderstandings out there. Yes, the government must follow its contracts. There is no government immunity for breaching a contract. Indeed, there are clauses in our Constitution, the Contracts Clause, the Takings Clause, that actually give even greater protections for those who contract with the federal government and may face a breach of that contract by the federal government. So bear in mind, there's no immunity for the federal government to break its contracts left and right. In fact, it is more difficult for them to do that. There has to be, as you've heard, a very strong basis. And they can't make it up today and say, oops, for the last 6 months, you failed to follow a policy we articulated yesterday. No, that's not how it works. If you're in the middle of a contract, they must stick to the contract terms. Now, it's a different question when it comes time to renew that contract. And that's where it's so critically important that you be prepared to read thoroughly what they want you to sign off on, determine with legal advice whether you can sign off on a new contract term that they may be seeking to add to your contract renewal, and determine how you move forward. In some cases, you may need to challenge what they are seeking to add in the ways that have been described for you. So, they have to follow contracts, matters what Congress does, and you do have recourse, due process, as described by Deborah, when they seek to wrongly modify or end a contractual relationship.
So on the issues of contracts, everyone here is based in California. California doesn't always agree with federal law. What should they do if you have contradicting terms where California grants indicate that you need to do something and the federal government now saying you need to do something different? What do you do in those cases?
Well, I would start by recognizing you're in California. State government should be your ally, and thus far has been, by and large, with respect to the Trump administration. So I would speak to your state contact first, and then potentially ultimately seek higher up review about a contradiction that you perceive, and see how the state perceives it. Now, that doesn't mean you have to take their word, because they're going to want to enforce state law, but they also understand that there is a federal government, and they may end up being the ones who litigate if you bring an issue to their attention. And while it is expensive, better the state government pay for that litigation through the Attorney General than you. So first and foremost, please consult with the state government when you see such a contradiction.
I could not agree more. And this is coming up right now with gender-affirming care. The federal government has made it abundantly clear that they don't think that gender-affirming care should be covered under Medicaid. And in the big, beautiful bill language that I've seen, though it's just a proposal, there is an exclusion for gender-affirming care for both minors and adults, which would make it impossible to get coverage for those services under Medicaid. We would anticipate, and I'm going to talk a lot, I'm sure at some point, about the dangers of anticipating, but I do think in this case we can reasonably anticipate that federal grants to healthcare providers will similarly include exclusion language governing gender-affirming care. And so, to the extent that you are a healthcare provider and you receive federal funds, there might be conditions attached asking you to certify that you will not provide gender-affirming care as a condition of receiving that money. That puts you directly at odds with California state law requiring providers to provide care irregardless of a number of factors, including gender identity. And the Attorney General has already flagged this conflict. I could not agree more. If this actually happens, and I think there's a reasonable chance that it will, healthcare providers should contact the Attorney General's office to make sure that they are not prosecuted by the Attorney General's office if they stop providing gender-affirming care for the purpose of continuing to receive the federal money that keeps them open and seeing all patients. So I think it is critically important to be communicative with the top law enforcement office in California in the event of a conflict between state and federal law.
If I could just add, I think it's important to note, of course, that if there is ultimately a conflict, unless it is challenged, then federal law is supreme under our system of government. Unless it is challenged. It could be challenged because it delves into an area that belongs to states to litigate. Okay? But ultimately, federal law is supreme. The key question is, what is federal law? Well, despite assertions by this administration, federal law is not what Donald Trump says it is. It is not what the Secretary of Health and Human Services says it is. It's what is established in legislation or through previous litigation. So that is what is supreme, not whatever Donald Trump says today, tomorrow, or the next day, or whatever the Secretary of Health and Human Services says today, tomorrow, or the next day. It has to be a real conflict of law, not of opinion, and then that would have to be resolved. But ultimately, in the meantime, federal law is supreme.
So one of the topics that you mentioned, I think in reproductive care, and since you talked about health care, in the past, organizations could provide certain services like abortion, and as long as they do not use federal funds for those services, they were okay.
Right.
Now we're seeing DEI and all the other areas. Has anything changed where now it's a blanket statement where they cannot provide any services whatsoever, or is it still allowable to provide certain services like as long as they don't use federal funds?
I think it really just depends on the topic. The administration is treating, for example, gender-affirming care differently than abortion. In the proposed Big Beautiful Bill language that I've seen, gender-affirming care is simply not covered by Medicaid anymore. So it's not to say that you can't provide gender-affirming care if you're a provider. You just cannot bill Medicaid for those services. Abortion is a little bit different. The proposed language excludes certain entities that provide abortion services. To be clear, it doesn't exclude abortion providers. It only excludes certain entities that provide abortions. It is very clearly targeting Planned Parenthood, the way that the language is described, and also other networks of abortion providers. But if you're a private physician and you see Medicaid patients and you provide abortions to those Medicaid patients in a state that covers abortion services through state-funded only programs, you can still participate in Medicaid. You are not a prohibited entity under the language, as opposed to an entity like Planned Parenthood, which would have to completely stop providing abortion services if it wanted to continue participating in the Medicaid program.
And Tom, are you seeing anything different, for example, like universities, where if they don't do something, they're completely being cut off, or the administration going or bringing action against them?
Well, I think we've all seen it in the headlines that there are certain universities being targeted, one in particular that is fighting back. I think that there is not legislation in this area that would have the effects, unfortunately, that we're potentially seeing in healthcare. But clearly this administration engages in targeted attacks. So it's not just Planned Parenthood, it's specific law firms that have had executive orders that name them and only address their purported violations of law. He is targeting specific universities, even though they do things that are very similar to most other universities in the country. So it is clearly an administration that attempts, through various means, to target specific entities. By the way, that's illegitimate under our Constitution. We don't often remember this, but our Constitution specifically prohibits bills of attainder, and a bill of attainder is a law that applies to only one person specifically. That's not allowed constitutionally. It never happened, so we don't really talk about those clauses in the Constitution. But what the administration is doing with the executive orders, with Planned Parenthood, with Harvard University, is clearly unconstitutional action. And it, I believe, will ultimately be brought to an end by the courts. Certainly, the one law firm executive order that has been challenged has been roundly condemned in court, and that law firm is on the way to a resounding victory against that order. Unfortunately, what we see is folks capitulate. So law firms have capitulated, cut deals with the administration about executive orders. Other universities have, in ways big and small, capitulated and agreed to pursue different policies because they have been targeted by the administration. And I think it's just important to note that capitulation is a danger to the Constitution, to the values of the Constitution, when we're talking about this kind of activity. That said, for many of those who are targeted, particularly smaller universities, smaller nonprofits, they are targeted, it may make perfectly rational sense to cut a deal. But I think it's most important that the sectors come together to work together so nobody feels so isolated and so alone and relying only on their own resources that they would feel an immediate need to capitulate were they targeted. They are going to choose, the administration is going to choose targets in the future. They've already said the deadline passed, but they said they were going to name big nonprofits and they were going to name specific philanthropy that they were going to start targeting for investigation. Now that deadline passed several weeks ago, but there's still expectations that that will happen. It's very important that we all unite and, where possible, really agree to mutual defense pacts where we work together so no nonprofit or small philanthropy or small college or small FQHC feels so alone that they feel the need to immediately give in to unreasonable demands from the administration. This is the time for us not only to be informed, but to be united and together in confronting the challenges posed by the ways that this administration targets specific entities and specific people.
So even legal defense funds have limited resources. Are you seeing anybody coming, joining forces to be able to provide help to those small non-for-profits that cannot afford to fight the executive orders, if that's what they want to do?
So yes, there are efforts that actually began after the Harvard and UNC affirmative action decisions in 2023, even before this administration, to provide pro bono advice to nonprofits about DEI issues, because we saw after that lawsuit, even before January 20th of this year, a number of lawsuits filed and financed by right-wing extremists targeting nonprofits. Probably the most famous is the Fearless Fund case, but targeting nonprofits, targeting businesses, targeting law firms, challenging their DEI, or as I say, EID activities across the board. So yes, efforts were put together. They continue to create consortia, to create collectives that can provide advice and, in some cases, litigation defense in circumstances where specific groups are challenged. Resources are needed, so I appreciate Deborah's plug, but yes, I think those efforts have started, but we need to continue to pursue them and deepen them and broaden them so there is a strong, strong sense of mutual defense, and nobody feels that they are alone in confronting the federal government in its excesses. And those efforts will continue, without a doubt. But there are effects. We are already seeing them. And to counter them, we need to come together.
I want to add, though, in the healthcare space, I think we have an unfortunate, especially in California, where we have, an enormous budget shortfall of our own that the governor is trying to reconcile, that the legislature is trying to reconcile. It has put champions for healthcare in the unfortunate place of needing to pick. Am I going to help doctors? Am I going to help hospitals? Am I going to help abortion providers? Am I going to help gender-affirming care providers? We are all in need of help. All of us are facing the Medicaid cuts and all of these other things that we're talking about. But there isn't enough money to make all of us whole. So it's very difficult for our elected officials, our champions in the legislature, to come together, because they have to, if they feel like they're being asked to pick their favorite. They're not looking at healthcare. They're looking at each type of provider, each cause. In the first Trump administration, for abortion providers in particular, we saw an enormous amount of support for abortion access funds. They were overflowing. This administration, that is not the case. And Tom and I were actually just talking about this before the discussion. It's not clear to me what exactly is different this time around, but these access funds, these legal defense funds, they do need your support. They had a lot of support during the first Trump administration. They are not seeing the same level during this administration, and arguably this is the time that they need it the most, that the foundations, that the nonprofits, they need individual donations right now more than ever. And that is not clearer to me than in the healthcare space. So just a plug to donate to a nonprofit of your choice in the healthcare space and a legal defense fund at your leisure.
I know we could keep talking for hours. Any last minute thoughts before we conclude this session?
Well, I simply have to say, elections matter. If anybody had any doubt about that, that doubt should have been wiped away on January 21st. Elections matter. And we have elections coming up, obviously, next year for Congress. And we will see every one of the members of the House of Representatives up for re-election or for an election of someone new. And it's critically important that you, all your colleagues, all your friends and family members participate in that election. You all know we see a drop-off in turnout between presidential elections and midterm elections. We can't see that this year. If anybody had any doubt that elections matter, that doubt should have been wiped away long ago, and you must participate in the upcoming elections.
Deborah?
So from the viewpoint of a compliance attorney, these days I feel like I am playing therapist as much as I am playing an attorney, and I'm a much better attorney, I assure you. So I would offer this. There is a line for business owners between taking action and catastrophizing. And I don't know where that line is, but it does exist. And I would suggest keeping that in mind when you're making decisions about everything that we talked about today. Meet with your team, gather your facts, do your research, really understand what is the scope of this thing. Is it really doing what it purports to be doing? And then before you take an action, revisit, where is that line? Am I catastrophizing? Am I implementing an order that doesn't even actually do anything? Or am I taking reasonable action for the sake of my business? They're different things, and for the sake of your own heart, I would urge you to make sure you are not catastrophizing. That's just gonna make things way worse than it needs to be. But run your business, take action, so find that line and use that as your North Star.
Well, Tom, Deborah, thank you so much for your time. Let's give a round of applause. Thank you so much for being here. And I think we now turn it over to Gil.
I hope, like I did, I learned quite a bit. Roger and I had lunch with Cal State LA. They had a $10 million grant. They were told they'd spent $1.5 million, had to return the grant because the grant specialized in helping undergrads get PhDs to serve in rural communities. So basically, it was targeting minority PhDs. And according to what I heard, I'm not so sure that they needed to return the money back because they did have a contract. But this is the kind of fear that is going on. This is the kind of interpretation that is taking place. So again, Deborah and Tom, thank you very much. It was a wonderful presentation.